Senator Harris,
Thank you.
you want to take over?
Judge, have you ever discussed Special Counsel Mueller or his investigation with anyone?
Well, it's in the news every day.
Have you discussed it with anyone?
With other judges, I know.
Have you discussed Mueller or his investigation with anyone at Kasowitz, Benson, and Torres, the law firm founded by Mark Kasowitz, President Trump's personal lawyer? Be sure about your answer, sir.
Well, I'm not remembering, but if you have something you want to...
Are you certain you've not had a conversation with anyone at that law firm?
Kasowitz, Benson.
Kasowitz, Benson, and
Yeah.
Torres, which is the law firm founded by Mark Kasowitz,
Yeah.
who is President Trump's personal lawyer. Have you had any conversation about Robert Mueller or his investigation with anyone at that firm? Yes or no?
Well, is there a person you're talking about?
I'm asking you a very direct question, yes or no?
I need to know I'm not sure I know everyone who works at that law firm.
I don't think you need to. I think you need to know who you talked with. Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking of who works.
Are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember.
Yeah.
How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
right,
please
I'm not
answer
sure.
the question.
I'm just trying to think. Do I know anyone who works at that firm? I might know.
Have you had? That's not my question. My question is, have you had a conversation with anyone at that firm about that investigation? It's a really specific question.
I would like to know the person you're thinking of, because what if there's...
I think you're thinking of someone and you don't want to tell us. Who did you have a conversation with at the...
I'm not going to...
Mr. Chairman, I'd like to raise an objection here. This town is full of law firms. Law firms are full of people.
First of all, I'd like you to pause the clock. Thank you.
The clock is paused.
Thank you.
Pause the clock. Let me raise my
The Senator is
objection.
recognized.
This town is full of law firms. Law firms are full of people. Law firms have a lot of names. There are a lot of people who work at a lot of law firms.
Responsibility to all Americans. Vote no. Be a hero. Vote no. You have a responsibility to all Americans. Be a hero and vote no.
And-
Be a hero and vote no. Be a hero and vote no. You have a responsibility to all Americans. Be a hero and vote no. Be a hero.
Senator Lee.
On that point, law firms abound in this town, and there are a lot of them. They're constantly metastasizing. They break off. They form new firms. They're like rabbits. They spawn new firms. But there is no possible way we can expect this witness to know who populates an entire firm that he's not even... My point of order, Mr. Chairman, is simply this. If there are names, if there is a list of names he can be given of the lawyers to whom she's referring, I think that's fine. But I think it's unfair to suggest that an entire law firm should be imputed into the witness's memory when he doesn't know who works at the law firm.
Mr. Chairman,
Senator Whitehouse.
we had
Are you making a point of order?
well,
Senator Whitehouse.
I'm trying to figure out what the rules are here, because we had a very, very long discussion about whether or not points of order were in order, because this is a hearing. And we were told that all of our points of order,
Senator Whitehouse,
all the documents.
there's never been a time in the 2 days where someone's made an inquiry of the chair where the chair hasn't recognized the member for a point of inquiry or a point of order.
And I've been
I was one
recognized
of
now,
them.
and I appreciate that. But my point is that if the rule is that nobody on our side can make a point of order, then it ought not to be appropriate for Senator Lee to start making points of order
But
after all of ours were summarily
Senator White,
silenced on the basis that we were in a hearing and not in an executive session. If we've moved out of hearing and into executive session, then I'm more than happy to make motions.
Senator
to
Whitehouse,
adjourn.
if the mere fact that you're speaking right now means that you've been allowed to make a point of order, the matter that you're talking about yesterday was a motion that the chair said was out of order because it was an adjournment motion that would have required us to be in executive session. Anyone who want to make an inquiry of the chair may do so, but we will limit it to that before we go back to Senator Harris.
Very good. That's the right result.
Sir, please answer the question.
I don't know everyone who works at that law firm, Senator.
And have you had any discussion with anyone ever about Bob Mueller and/or his investigation?
So you said Bob Mueller, so have
Or
I ever
his-
had a discussion about Bob Mueller? I used to work in the administration with Bob Mueller.
What about his investigation? Have you had a conversation with anyone about his investigation?
I'm sure I've talked to fellow judges
Anyone aside from fellow judges?
about Bob Mueller.
About his investigation, sir? I'll ask again.
But-
I asked the question just a minute ago. I'm surprised you forgot. Have you had this conversation with anyone about the investigation that Bob Mueller is conducting regarding Russia interference with our election or any other matter?
The fact that it's ongoing, it's a topic in the news every day. I talked to fellow judges about it. It's in our, it's in the courthouse in the District of Columbia. So I guess
And I'll ask
the
you
answer to
one
that
last
is
time.
yes. So the answer is yes.
Okay, and did you talk with anyone at Kasowitz, Benson, and Torres?
You asked me that. I need to know who works there.
I think you can answer the question without me giving you a list of all employees of that law firm.
Well, actually, I can't.
Why not?
Because I don't know who works there.
So that's the only way you would know who you spoke with? I want to understand your response to my question, because it's a very direct one. Did you speak with anyone at that law firm about the Mueller investigation? It's a very direct question.
Right. I'd be surprised, but I don't know anyone. I don't know if I don't know everyone who works at that law firm. So I just want to be careful because your question was and/or. So I want to be very literal.
That's fine. I'll ask a more direct question if that's helpful to you. Did you speak with anyone at that law firm about Bob Mueller's investigation?
I'm not remembering anything like that, but I want to know a roster of people, and I want to know more.
So you're not denying that you spoke with
Well,
anyone?
I said I don't remember anything like that.
Okay. I'll move on. Clearly, you're not going to answer the question. When you and I met, we talked about race relations in this country, and there's been a lot of talk among my colleagues with you about the subject. And when you and I met, I brought up the incident in Charlottesville, where, as you know, there was a rally by white supremacists that left a young woman dead. You will recall that the president who nominated you described the incident by saying, quote, "I think there is blame on both sides." So I think this will be a simple question for you. Do you, sir, believe there was blame on both sides?
Senator, we did talk, and I enjoyed our meeting, and to talk about the history of this country, and we talked about that at some length and talked about discrimination. I appreciated your opening statement yesterday where you talked about your experience. One of the principles I've articulated throughout this hearing is the independence of the judiciary.
And sir, I'd appreciate if you'd answer the question.
I am, Senator. So one of the principles I've talked about throughout this hearing is the independence of the judiciary. And one of the things judges do, following the lead of the Chief Justice and what all the judges do, is not stay out of current events, stay out of commenting on current events because it risks confusion about what our role is. We are judges who decide cases and controversy. We're not pundits, so we don't comment on current events. We stay out of political controversy.
Judge, with all due respect, I only have limited time.
But it's,
Are you saying that it's too difficult a question or it's a question you can't answer, which is whether you agree with the statement that there was blame on both sides? We can move on, but are you saying you cannot answer that pretty simple question?
I'm saying that the principle of the independence of the judiciary means that I can't insert myself into politics in either of two ways, commenting on political events or, in my view, commenting on things said by politicians, a governor, a senator, a congressperson, a president. I'm not here to assess comments made in the political arena, because the risk is I'll be drawn into the political arena, and the justices and judges of the
Sir,
United States.
and I appreciate your point. But there was such a robust conversation that happened, especially with my colleagues on the other side and you, about race. So on the subject of race, I raised this question, but we can move on. Have you ever heard the term, quote, racial spoils system?
Yes, and that is a term that sometimes is used to, yes, I've heard that term.
You twice wrote the term in the Wall Street Journal opinion piece describing the Cayetano case that you discussed previously with Senator Hirono. And I'll tell you, the racial spoils system, that term stood out to me, so I actually decided to look it up in the dictionary, the term spoils. And in the dictionary, spoils is defined as, quote, goods stolen or taken forcibly from a person or place. Can you tell me what the term racial spoils system means to you?
Senator, first of all, the Supreme Court affirmed the position that I had articulated in the amicus brief 7-2 in Rice versus Cayetano, an opinion written by Justice Kennedy. Second of all, the state voting restriction at issue in Hawaii was a state office, not for the Native Hawaiian.
Judge, that's not what I asked you.
But it
if
didn't.
You can define the term as you used it. What does it mean to you?
But I need to, you raised the case, and the state voting restriction in that case denied Hawaiians, residents of Hawaii, the ability to vote on the basis of their race. So if you were Latino or African American, you could not vote in the election.
And I heard your response to that earlier, and I appreciate the point that you made then. My question is, you used this term twice, and I'm asking, what does the term mean to you?
I'm not sure what I was referring to then, to be entirely frank. So I'd have to see the context of it. But what I do know is that the Supreme Court, by a 7-2 margin, agreed with the position articulated in the amicus brief, and that the voting restriction there was for a state office and denied people the ability to vote on account of their race. So it was...
Sir, I appreciate that, but you've been very forthcoming about the amount of work and preparation that you put into everything you do. You have certainly led me to believe that you're very thoughtful about the use of your words and your knowledge that words matter, especially words coming from someone like you or any one of us. And so I would like to know what you meant when you used that term, but we can move on. But I will say this. Are you aware that the term is commonly used by white supremacists?
Senator, when I wrote that was 20 years ago in the context of a voting restriction that denied African Americans and Latinos the ability to vote in Hawaii. That I was representing a client when I articulated that, and the answer to your question is no.
Okay. Well, unfortunately, it has been, and it is something that you should know. You should know that the same year you wrote your op-ed, a magazine published a cover story, a magazine that is described as being a white supremacist magazine, published a cover story about what it called, quote, the racial spoils system of, quote, affirmative action, the double standard in crime, sensitivity toward black deficiencies, and everything else. The same year, a self-proclaimed Eurocentrist wrote, quote, while blacks are generally regarded as the recognized expert in the game of racial shakedown, it is American Indians who may actually be the real geniuses at obtaining, quote, racial spoils. So we can move on, but my concern is that this is a loaded term, and it would be important to know that someone who may very well and very possibly serve on the United States Supreme Court would be aware that the use of certain terms will have a profound meaning because they are loaded and associated with a certain perspective and sometimes a certain political agenda.
Well, I take your point. I would point out that Hawaii was denying Latinos and African Americans the ability to vote in a state election at the time, but I take your point and I appreciate it.
Thank you. In Griswold and Eisenstadt, the Supreme Court said that states could not prohibit either married or unmarried people from using contraceptives. Do you believe Griswold and Eisenstadt were correctly decided?
So those cases followed from the Supreme Court's recognition of unenumerated rights in the Pearson-Meyer cases earlier. And so what those cases held is that there's a right of privacy.
And do you agree, do you personally agree that these cases, those two cases, were correctly decided? So I'm asking not what the court held, but what you believe.
Right. So so to just go back to Pearson-Meyer, those cases recognized a right of privacy, the ability, one might say family autonomy or privacy, the term under the Liberty Clause of the Due Process Clause of the 14th Amendment.
And with due respect then, Judge, I'm asking, do you agree that those cases were rightly decided?
So I think
correctly
Griswold, so on Griswold, I think that Justice White's concurrence is a persuasive application because that specifically rooted the Griswold result in the Pearson-Meyer decisions. I thought that was a persuasive opinion. And
do you believe that it was correctly decided?
No quarrel with that.
Do you believe it was correctly decided? Words matter, again, words matter. Yeah. Do you believe it was correctly decided?
I think given the Pearson-Meyer opinions, like I said, Justice White's concurrence in Griswold was a persuasive application of Pearson-Meyer. I have no quarrel with it.
So there's a term that actually both Chief Justice Roberts and Justice Alito used, I believe, and affirmed in their confirmation hearings that these cases were correct. And so I'm asking you the same question. Are you willing in this confirmation hearing to agree that those cases were correctly decided?
Well, given the precedent of Pearson-Meyer, I agree with Chief Justice Alito and Chief Justice Roberts, what they said.
That it was correctly decided?
That's what they said.
Do you believe the right to privacy protects a woman's choice to terminate a pregnancy?
That is a question that, of course, implicates Roe v. Wade, and following the lead of the nominees for the Supreme Court, all 8 currently sitting justices of the Supreme Court have recognized that 2 principles that are important. One, we shouldn't talk about, in this position, cases or issues that are likely to come before the Supreme Court or could come before the Supreme Court. And secondly, I think Justice Kagan provided the best articulation of commenting on precedent. She said we shouldn't give a thumbs up or thumbs down.
No, I appreciate that, and I did hear you make reference to that perspective earlier, but you also, I'm sure, know that Justice Ginsburg, at her confirmation hearing, said, quote, this is on this topic of Roe, quote, this is something central to a woman's life, to her dignity. It's a decision she must make for herself, and when government controls that decision for her, she's being treated as less than a fully adult human responsible for her own choices. Do you agree with the statement that Justice Ginsburg made?
So Justice Ginsburg, I think there, was talking about something she had previously written about Roe v. Wade. The other 7 justices currently on the Supreme Court have been asked about that and have respectfully declined to answer about that or many other precedents. It's all the, whether it was Justice Marshall about Miranda or about Heller or Citizens United. Mm-hmm. And it's rooted, I just want to underscore, it's rooted in judicial independence.
No, I appreciate that, but I'm glad you mentioned that Justice Ginsburg had written about it before, because you also have written about Roe when you praised Justice Rehnquist's Roe dissent. So in that way, you and Justice Ginsburg are actually quite similar, that you've both previously written about Roe. So my question is, do you agree with her statement, or in the alternative, can you respond to the question of whether you believe a right to privacy protects a woman's choice to terminate her pregnancy?
So I have not articulated a position on that, and consistent with the principle articulated, the nominee precedent that I feel duty-bound to follow as a matter of judicial independence. None of the 7 other justices have, when they were nominees, have talked about that, nor about Heller, nor about Citizens United, nor about Lopez versus United States. Thurgood Marshall, about Miranda, Justice Brennan asked about...
And respectfully, Judge, as it relates to this hearing, you're not answering that question, and we can move on. Can you think of any laws that give government the power to make decisions about the male body?
I'm happy to answer a more specific question, but
Male versus female.
there are medical procedures.
Okay? That the government has the power to make a decision about a man's body?
I thought you were asking about medical procedures that
No,
are unique to men.
I'll repeat the question. Can you think of any laws that give the government the power to make decisions about the male body?
I'm not thinking of any right now, Senator.
When referring to cases as settled law, you have described them as precedent and, quote, precedent on precedent. You've mentioned that a number of times today and during the course of the hearing. As a factual matter, can 5 Supreme Court justices overturn any precedent at any time if a case comes before them on that issue?
You start with the system of precedent that's rooted in the Constitution.
I know, but just as a factual matter, 5 justices, if in agreement, can overturn any precedent. Wouldn't you agree?
Senator, there's a reason why the Supreme Court doesn't do that.
But do you agree that it can do that?
Well, it has overruled precedent at various times in our history, the most prominent example being Brown versus Board of Education, the Erie case, which overruled Swift versus Tyson.
So we both agree. We both agree the court has done it and can do it.
There are times, but there's a series of conditions, important conditions, that if faithfully applied, make it rare. And the system of precedent's rooted in the Constitution. It's not a matter of policy to be discarded at whim.
But there's nothing, you and I agree, that prevents the court from doing it, meaning that it is not prohibited. The court is, if I may finish, the court is not prohibited from overruling or overturning precedent. No matter what the steps are that the court must take, the court may overrule precedent. And so my question also is, then, do you believe that this can happen no matter how long the precedent has been on the books? There's no, for example, there's no statute of limitations during which, after that statute of limitations is passed, the court may not touch precedent. Would you agree?
Well, for example, the Supreme Court this past year said that Korematsu had been overturned in the court of history. That, of course, was the case that allowed the internment of during World War II
yes, I'm
of
familiar
Japanese Americans in the Supreme Court this past term. That was a 1942 or 3 decision in the Supreme
But you'd
Court.
agree there's no statute of limitations. The court can go back as far as it wanted if it believed it was warranted. There's nothing that prevents the court from reaching back many years.
What I would say is there are a series of conditions that the Supreme Court must meet, and the age of a precedent, as I think the Supreme Court itself has articulated many times, does ordinarily add to the force of the precedent and make it an even rarer circumstance where the court would disturb an old precedent.
Thank you. I have a couple of questions for you about voter suppression. Our history, as you know, is littered with shameful attempts to deny voting rights, especially for communities of color, and in particular the African-American community in this country. For 50 years, the Voting Rights Act protected against racial discrimination in voting. I know you had this conversation, part of this, with my colleague, Senator Booker. Under the Act, it states that a record of discriminatory voting practices had to obtain federal permission in order to change their voting laws. I know you're familiar with that. But then came the court's decision in Shelby, and by a 5-4 vote, the court gutted the act, effectively ending federal approval requirement. The majority believed that the requirement had outlived its usefulness. As you know, that was part of the ruling, essentially saying that the threat of race-related voter suppression had diminished. So my question is, are you aware that within weeks of the Supreme Court's ruling, Republican legislators in North Carolina rushed through a laundry list of new voting restrictions that disproportionately disenfranchised racial minorities? And it's just a yes or no question. Are you aware of that?
I recall reading about efforts in the aftermath, but one thing I would point out is I believe the Supreme Court's concern in that case was with the formula that was used for which states were covered by the preclearance requirement. I do not believe the court said that Congress was proscribed from going back and redoing the formula. So on the outlived its usefulness, I believe what the court said, I'm just describing it, not saying whether I agree or disagree, was saying the formula had not been updated to reflect current conditions, but was not saying that preclearance was precluded if Congress went back and adjusted the formula and studied current conditions.
Are you aware, as it relates again to that North Carolina action, that the Federal Court of Appeal later held that these restrictions intentionally discriminated against African American voters, targeting them, quote, and these are the words of the court, with almost surgical precision? Are you aware of that ruling?
When was that decision, Senator?
That was, I believe that was in it was shortly after, a few years ago, not 2016.
I'm aware that there's been a lot of voter ID litigation and other voting-related, election-related litigation in North Carolina, in particular, over the last several years. And so I'm generally aware of all the litigation in North Carolina.
And are you aware that Republicans in Texas, Alabama, Mississippi, Georgia, and Florida have also implemented new voting restrictions since Shelby, again, disproportionately disenfranchising minority voters?
Well, I know there's, I'm not aware of the specifics of all that, but I do follow election law blogs and election law updates to keep generally aware of developments in the election law area. It's an area.
Wouldn't you agree then, reading about this on the blogs, that it's troubling? In fact, compounding those with the recent proposal to close more than 2/3 of polling places in Randolph County, Georgia, where more than 60% of the residents are black. Wouldn't you agree that that's troubling?
I'm not aware of that specific, but as I had the South Carolina voter ID case, what I tried to make clear through the trial in that case and the opinion, which was unanimous, that the reality of racial discrimination in America exists.
Yeah.
The long march for racial equality is not over, and that courts must scrutinize efforts to look for discriminatory intent or discriminatory effects. Can always be evidence of an intent, and on certain laws, the effects themselves can be problematic.
And do you believe that the court in Shelby underestimated then the danger that states that was presented in terms of states' willingness to restrict the right to vote?
Well, I don't want to comment on I think that's getting to the correctness or incorrectness of Shelby in particular. I just want to underscore, at least as I recall the opinion, it did say Congress itself could adjust the formula for preclearance, and I don't think Congress has done so, but that's
clearly unwilling to do it. So there will have to be some recourse, don't you agree, for those voters in these various states, if Congress is unwilling to act, to give them due process in terms of equal access to the polls so that they can vote. Otherwise, we're looking at widespread disenfranchisement. Wouldn't you agree, if Congress doesn't act?
So Shelby dealt with the preclearance requirement. There's still, of course, Section 2 of the Voting Rights Act, which allows litigation brought by plaintiffs to challenge voting restrictions that are enacted with discriminatory intent or discriminatory effects as well.
Do you believe that Section 2 is constitutional?
I think that's asking me a hypothetical that about any statute.
Because you referred to it, I would like to know.
Well,
I would assume that you think it's constitutional if you think it's a tool.
Well, I think as a general matter, I don't want to pre-commit on any statute that you would identify. If there's some challenge raised, I'll of course listen to the arguments. But Section 2 is an important tool for the voting rights enforcement. The Voting Rights Act of 1965 is one of the most consequential and effective statutes ever passed by Congress in terms, and I've said that, and the history is of course well known, but the voting rates before the 1965 Act were abysmal because of the discriminatory restrictions that were in place, and the immediate effects of the Voting Rights Act of 65 were enormous and are very important for people to understand.
I agree. And in fact, to that point, in his confirmation hearing in 2005, Chief Justice Roberts, when asked about Section 2 and whether it was constitutional, said, quote, "I have no basis for viewing it as constitutionally suspect, and I don't." Do you agree with Chief Justice Roberts that the law is not constitutionally suspect, or do you have a different view?
I don't have any basis for viewing it that way either. I was just, if you ask me about any statute, I want to be careful because I don't know what arguments could come up, and I always want to make sure I've preserved the judicial independence and have not pre-committed. But I agree, I have no basis for doing that.
And then after the president nominated you to the Supreme Court, you had a chance before now, it was the only chance actually before now, to introduce yourself to the American people. You stood in the East Room of the White House and you thanked the president for your nomination. And then immediately you said, quote, "No president has ever consulted more widely or talked with more people from more backgrounds to seek input about a Supreme Court nomination." Now, by my count, there have been 163 nominations to the Supreme Court. So unless you have personal knowledge about every one of these nominations before yours, including who those presidents consulted with and who they talked to, and I can't imagine that you have that personal knowledge. My question is, did someone tell you to say that?
No one told me to say that. Those were my own words. They were based on I did look into it a little bit in terms of thinking about what was possible before cell phones and before phones, and then thinking about the history. And I know some of the history of Supreme Court nominations, and I also know in that 12-day period, I do know that President Trump talked to an enormous number of people. I think President Clinton, when I look back on it, that's why I said no one done more. President Clinton, as I recall, had a consultation process that was very wide as well. But that was my analysis of the situation. Those were my words, entirely my words. And I thought it was important to point out because I was, as I said yesterday, I was deeply impressed by the thoroughness of the process during the 12 days. And I said as much yesterday, and I said as much in the East Room. The 12-day process was, at least it seemed to me, quite a thorough process.
Okay, thank you. And then I'm going to follow up with some questions for the record for you on the first question I asked.
Okay.
Thank you. Thank you.